Okay, now we're going to actually, now that you have the actual FTC affidavit done, we're going to have to send out 2 documents with the actual FTC affidavit. We're going to be sending out the 2 freedom of information request forms. This one here and this one. Okay. So let me go over, before I go over the little details about what these forms that you're sending out, I want you to understand what an actual freedom of information request is. Okay. So I've already prepared some things for you. Let me actually pull it up. All right. I want you guys to start getting used to using the actual Googles. Make Google's your friend. So what is a freedom of information request? Now this is an act that was passed. Okay, way back when, and short for FOIA, Freedom of Information Act, gives you the right to access recorded information held by the public sector organization. Anyone can request information. There are no restrictions on your age, nationality, or where you live. Okay, that is very key right there. So basically, what actual freedom of information request is: any business, company, corporation, non-profit organization, government agency, public official, anyone, your friend down the street, but I don't recommend you actually sending that to a friend, just a regular individual. You could, it's legal if they're and you're well in your legal rights, but the purpose of this is to go in conjunction with this actual debt that they're basically saying that you owe them. And you're basically saying, this is a 7-year-old debt, I don't owe you anything. So what a freedom of information request does for you, it allows you to request from them. You see right here where it says freedom of information request and request for affidavit certifying information of statutory obligation made to, and you're going to put down the company that you're sending this to, the name of the big company that basically is trying to say that you owe them money or debt. So a freedom request basically is asking you to give you information, pertinent information about this debt that they say you owe them. And under the Freedom of Information Request Act, they have to do it. It's mandatory. Anyone that sends a Freedom of Information Request letter to any one individual corporation or business, they have to abide by that, act, Information Act, FOIA Act. So, and it's enforced by the FTC, it's enforced by the government, it's enforced by that law. Okay? So, you're going to be asking them this. Basically, you're going to be asking this company, whoever the company you put down, student loan, auto loan, that is basically trying to collect from you 7 years. We're talking about 7 years old. Then this applies to any debt, but we're talking about a loan that's 7 years old and past that. Okay. The purpose of this freedom of request, information request, is for the director of this financial institution, an actual owner institution, who are under oath and obligations to the United States laws and statutes to provide a copy of the original contract pursuant to, and this is a case right here, certifying that they are the actual holder of the original instrument of question and are willing to have it inspected for authenticity in regards to alleged account number, and you're going to put your account number right there. Don't worry about a CUSID number. Just put your account number, the ones that they're saying you owe money. And to provide an affidavit certifying their information that they follow all applicable federal, state, and contract law. See, federal, that's one area of actual laws. State, the state that you reside in, laws. And contract. Contract is actually universal. It covers everything. There can't be any laws without any contracts, okay? And carrying out the alleged contract of note, account number, and you're going to put that same account number right here to satisfy the requester that this financial entity is operating within the bounds of the law that the financial entity is subject to, and that they have a legitimate claim as a creditor and holder in due course. You're going to learn as you go with this actual lesson store what a creditor and holder in due course is. Specifically, the law includes the National Bank Act, also known as the National Current Act, the Consumer Credit Protection Act, the Fair Debt Collection Practice Act, the Fair Collection Reporting Act, and the Truth in Lending Act, and any of all laws applicable to financial institutions, whether they are federal, state, or contractual commercial laws. So you have to understand, you can look these acts up for you guys. I recommend that you do, so you can actually familiarize yourself with the difference between holding due course, creditors, Currency Act, National Currency Act, Consumer Act, Protection Act, Federal Debt Collection Practice Act. I went into the details about that. The Fair Correcting Reporting Act, Truth in Lending Act. These protect you as an individual, as a said citizen, and you're a citizen of the Corporation of United States. So they have to actually abide by a lot of rules and guidelines, and they can't take advantage of you. So this is what this is. You're asking them in a letter that for them to disclose information about this credit that they say they owe you, this debt that they say they owe you, not credit. Apologize for that. And then you're asking them to provide an affidavit certifying. So down here is right here. You're going to put the name of the company that you sent it to again, like you did up here. Same one right here, like you did right here. You put it down here as well. And you're basically asking them, you don't leave this blank. You just put the company name down there, or you could just leave it blank. I would advise you just leave it blank and let them fill it out. Put their names, corporation that you're going to put down, and leave the rest of it blank. Why? Because this is, if you notice, requires a notary signature, and it requires them to actually sign as well that they are sending you the paperwork or disclosing information, pertinent documents, that they're the holder in due course, that this is a real true debt that they owe you. Now, this is not a true debt. It's not. Anytime it goes to a debt collector, anytime it's past 7 years old, they cannot put a debt on you. But they will evade you, run from you, avoid your calls, but they'll call you and harass you, telling you to keep paying them. And they will mess up your credit. So you want to actually take the lead. You want to actually take action and get this remedy resolved. You want to get this actual debt issue resolved. So you're not going to get it resolved sitting down burying your head in the sand like an ostrich. Okay, you want to actually get out there in front of this and use what you have in front of you, which is to your rights that you have in front of you, which is consumer protections. A whole bunch of protections protect you from predators that just want to collect just because they can. And just because you allow them to. That's why they can. So when you challenge them with the letter saying, send me documents showing that I owe you this money, and also certify with an affidavit, basically go to a notary and actually sign it in front of a notary stating that I do owe you this money, then we could talk. They won't send you that. The reason why they won't send you that is because it places them in a position of perjury, of lying, of what is it called, of the truth coming out. It places them in a place of that they can be sued. So if anyone at the corporation signs their name on here saying that you owe them a true debt, and they in front of a notary, and they send you documents, that's ball game. They just basically crucified their corporation, their business. They won't do that. So they'll just ignore you, and they'll send you documents back that are kind of documents saying that no, you owe this, or they'll start their own investigation. They'll basically do things that are out of the norm, stuff that you're not asking them to do. Okay. And when they don't do that within 30 days, that's when you take the next steps that I'm going to tell you to do. So let me read this little part down here. I am officially requesting the following. You produce the original contract. Now you can read the rest of that, okay? Number 2, provide an affidavit certifying that you did not breach any federal, state, contractual, commercial, or official oaths or laws carrying out. See, they have oaths that they've taken to protect you and not take advantage of you. Each state, each federal. So any business that is opening up doing business with you, corporations and nonprofit organizations and LLCs, they have to abide by the federal laws, the state laws, and United States laws as well. Okay? They have rules that protect you. So, number 3, certify that you did not unlawfully, without my consent, use my signature to materially alter, falsely endorse, stamp, convert any contract bearing my name or signature into a security in order to convert my contract into an asset. See, they do a lot of money on Wall Street. They do a lot of things with your signature and the actual debt that you owe them. And they needs you. I don't even know if that is actually proper English, but they need you to actually continue paying them so they can securitize this debt and make money after money. Especially when they set it to a creditor, the ball game's up. They got insurance, they got paid. It's so much into debt that they need you to be a debtor. And when you challenge them the correct way, it's ball game. It's over. What I mean by that, they cannot go any further. But you got to complete the task. Okay, so that's that one. And then the next one is a freedom of request. Same thing, a letter. Now that you know what a freedom of request is basically asking them more information now, securitization inquiry. You want to know if they securitize this. When I talked about if they did stuff on Wall Street, if they actually sent it to other agencies, if they actually monetized this more than what it was. Okay, the purpose of this freedom of request is for the director of this institution and the actual owner of this institution. See, it's the same pretty much thing. You put the account number right there, your account number that you're challenging. And you also put the account number right here. Okay? And you're asking them right here, please provide me the name, any parent companies. See, because they do a lot of that right there too. They'll actually have subsidiaries and parent companies with the same name. Sally has a way of, Sally Mae with student loans, they do that all the time. Trickeration, they do the federal government student loan. They're Navant, they're on that new thing right now in Navant. But it's the same company. Okay. Then you also, number 2, please provide the EIN number and QSIP number of the company, corporation, financial institution. You want that. Please provide an affidavit stating that you have enforceable payments, interest, and contract in the contract account number, and you put your account number down there. Based on security files, that's details that if you want to look this up, you're more than welcome to. And I actually advocate or push that you actually do. Please provide documents pertaining to any stocks, securities, bonds, basically asking them provide me all that. It's your account. It's your signature. You're making payments to them. You're on the contract, at least they say you are. You have the right to ask for any information showing that they have made money off this actual account and how much they actually making off this account. And why are they making this money on account? You want every detail about this account. If you're paying on it, just to be paying nobody just because you're supposed to. Know your rights. Know your rights. You wonder why you can do a bankruptcy every 7 years? Because they don't supposed to stay on your record for past 7 years. Period. And they just sit there even though you've been paying for 7 years. The same. But I still have to pay when I owe that loan? I still owe that loan, so I should be paying. No, you don't have to continue paying. Because the actual law says you don't have to pay anymore if it's 7 years old, whether you still owe it or not. That's just the truth. You go look it up. Provide an affidavit certifying that you did not breach any federal, state, contractual, commercial, or any oath. See, there it is again. Number 6, certify that you did not unlawfully, without my consent, use my signature. And you're probably saying they did use my signature. No. We're talking about more things that they actually open up, securitization with security bonds, etc. Stocks. They're doing this with this same debt. And you're probably saying to yourself, they wouldn't do this with no car debt, student loan debt. Yes, they will. They do it all the time. They've been doing it for 20, 40 plus years, 50 plus years. They will. So down here, you put down the financial institution's name, and then you put down their name as well down here. And then you leave this blank because they have to take this sheet down to a notary, see, notary's signature, and have them actually sign. Under penalty of perjury, they're supposed to be actually stating that they send you a lot of information concerning the documents you're asking for, which is freedom of request, information request, anything they have on this, as well as you want them to go get it notarized in front of a notary. Now, when they don't send this back to you, it's over. Because you're going to give them 30 days. You're going to send the FTC affidavit. You're going to send the, you're going to send the FTC affidavit, the one we just filled out. And you're going to also send these 2 freedom of request, both of these, at the same time. You're going to give them 30 days to respond. And when they don't respond in 30 days, that's when you're going to send this last form right here, because they're going to respond with some mess talking about this is your documents, or they're going to call you, or they're going to send a FTC letter. They're going to open up a case with Equifax, Experian, and TransUnion. It's several things they might do. Just investigating. You might get phone calls and letters from the actual company saying that, okay, we investigated it and you do all this legit. That ain't what you're asking, okay? So please understand, they must, by the Freedom of Information request. When you request it, it's a demanding by the Freedom of Information Requests Act. That is, they have a law out that they have to do this right here. They have to do this. And when they don't, they actually breached their contract. They actually did not follow through with the obligations that you asked them to do. That's what it is, okay? That's where your weight is. When you send this right here to them and they do not follow through what they're supposed to follow through, they have now, the contract is over. They cannot continue with you. You can actually, so they can say whatever they want through phone calls. They can write you and send you whatever they want through phone calls. If they do not complete these two forms, it's over. That means that they don't have anything. Under their rules of state, federal, as well as the government and the United States, they have no weight. They cannot continue collecting from you. That your rights are protected on several acts, and especially a consumer. So when they don't respond, the correct way with this is what I'm going to make clear. An affidavit has to be filled out and notarized in front. They have to have this notarized in front of a notary with documents sent to you, giving you every detail about this account. They won't do it because they know they're lying, period. And you got to challenge them on it. They will continue. They definitely, most likely will continue. Sometimes they drop off and they leave you alone and they say the account is paid in full. But when the 30 days is up, you make sure you send this last letter. Information of cancellation of contract by grantor, trustor, or primary issuer. Don't worry about all these names. Grantor is basically you. Trustor is you. You're the big dog. You're the boss of this actual account. Administer default judgment. Default means they have defaulted. They're within the time limit and they didn't send you what you asked them. So now you're canceling the debt. You have the right to do that because anybody on the contract, they have the right to ask for information. That's what the Freedom of Information request is. See, Freedom of Information request is. Anybody has the right to ask for that. Made to notary for failure to produce Freedom of Information request and request for affidavit. Both. When they don't do both, it's over. You have the right to cancel a debt. Certifying information of statutory obligation made to the name of the financial institution / state corporation entity department supervision. The purpose of this affidavit is to certify the information request was made to the above named corporation entity on date, and you're going to put the date right there. So you're going to make sure you put the actual corporation, see, name of financial institution. You put it right there, whether it may be Sally Mae's, card loan, whatever. And the corporation entity and fiduciary failed to produce the Freedom of Information request and failed to produce the affidavit certifying that they affirm their activities in regards to this account number. Put the number right there. Okay? Yeah, the number goes right here. Were within the bounds of the federal, state, contract, and commercial statutory obligations and oath of record that they were bound to. So they didn't send you none of that. And failing to provide such certification, the fiduciary, and the fiduciary is the person that actually handles the account, that's over the account. It might be a CFO, CEO, the person that is over your account, everyone's account. The fiduciary. You can put that person's name down there if you want, and all agencies. I would put the CFO name, or I wouldn't go lower, like I said before, than an actual vice president. So try to make sure you have a president's name right here, lower than basically a president. Make sure you put the president's name, CFO, CEO, whichever one you can come up with. And you can Google them their names. And all agencies have shown bad faith and default in their lawful duty to record, to legally verify. You're asking for verification, the alleged claim, as required by law and as stated specifically in the oaths of office, which obligate them to follow the laws mentioned within those oaths and applicable laws. Okay? You put your name right here. The affidavit, short for affidavit. And this affidavit am officially executing administrative default to reflect for the record along with color of authority actions based on the following. So you put your name right here, okay? And those are the things that you're basically saying that they did wrong. Number one, alleged complaint failed to produce the original signature, and so on. Number two, alleged claimant failed to provide an affidavit certifying that the fiduciary for the institution they did not breach the federal. They failed to do that. Affidavit completed. Number three, alleged claimant failed to certify that they did not unlawfully, without my consent, use my signature. So a lot of things they failed to do. Alleged claimant was and is bound by law, all the laws that was in the actual freedom request, to provide this information upon request pursuant to the FOIA USC 5 section 552. You can look that up if you want to. And failed to. You have 10 days. Now you're giving them 10 more days to reply, letting me know in writing that this negative account is in question will be removed from my report, and or I will promptly file this case in small claims court for violations of the FDCPA, Federal Debt Collection, Fair Debt Collection Practice Act. That's what you're basically saying, okay? You're going to go in front of a notary, and you're going to put your name right here, county to state, and you're going to actually put your what date that it was done, year, and then the notary is going to put their signature right there. That's it. That's all you need to do. And when you send that in, and they do not remove that within 10 days, and you don't get that removed, start your small claims action. Like I said before, a small claims action does not take much to complete. In most states, it costs less than $60 to start a small claims action. And when you start a small claims action, you have to initiate the suit, and then you put the person's name down there, the corporation's and business's name down there, and you get a process server, or you most likely, some states you can do it by mail. Find out how you're going to serve the party, letting them know a lawsuit has been completed. A small claims is simple. You just fill out the front, and you actually go through the details. They're going to give you the assistance when you go down there. Fill out the front, and you're going to attach, when you initiate this suit, you're going to attach your exhibit A, B, and C. What are your exhibit A, B, and C? Your first exhibit is going to be the FTC, one that you filled out. Your exhibit B, that's be exhibit A, the FTC. Going to attach that. Your exhibit B will be the actual green card, because you're going to send this out, certified mail return receipt. That's a green card. Certified mail return receipt. That means you want a signature that they got it. You're going to attach all the green cards. I mean, well, just really two of them, because counsel of the debt, you want to send that out with the certified mail return receipt, and you want to see the FTC as well as these two freedom of information request letters. That's a green card. So you have two cards all together, because you're going to give them 30 days to respond to the FTC and the freedom of information request, to these two right here. They're going to go in the same, all three of these go in the same letter. Then the cancellation of the debt. So exhibit B will be the green letters that you actually send out to them. Then the return receipts that they signed for. Excuse me. Number 3, exhibit C will be these right here. See? Information of what is it called? Cancellation of the freedom of right here. I'm sorry. Number 3, exhibit 3 will be information of cancellation of contract. You're going to attach that in the back. You want to basically attach everything that you sent to them as your A, B, and C exhibits, as well as the freedom request. You can put those back there as well. These two right here. Attach those to your as your exhibits. Now, when you actually send them a copy, you're going to want to go down to small claims court, and you're going to file it, and you're going to want to make 3 copies. One for the courts, and then one maybe sometimes for the chambers, and they'll give you a copy. And then you're going to have to mail out. You probably want to take down 4 copies just in case. You're going to, and they'll tell you how to fill it out. They'll help you with it. Sometimes they will, sometimes they won't. It depends on who's at the window. But they have a packet right there. All courts have packets with the instructions showing you how to fill them out. And the small claims is the easiest. So when you follow the instructions and fill it out, you send. They'll give you a certain amount of time to serve the proof of service. Basically, serve the other party, which is the corporation that you started a small claims court. And we're not suing the business here, okay? We're not doing that with small claims. We're actually, because remember when this went out to all the, right here, Equifax, Experian, TransUnion. You can do all 3. or you can do one or two. If I did any of them, because most of them will follow. If I did any, because they'll correct your information, I would do TransUnion and Experian. So you can put them all on the same form, as long as you stay under the certain amount of money for suing these individuals within that actual state. Some states in small claims court, you could sue up to $1,500, and then once you go past a certain amount, it actually turns into an actual civil suit, or now you're a superior court or a federal court. You don't want to be suing past the certain amount that you can sue for, and if it's $2,500, stay under the limit. So combined, you can sue all three of these people, as long as you stay under the combined set amount for small claims. So, for example, if the state told you you could sue up small claims, you could sue up to $2,500. You can put all their names on there on the same lawsuit, suing them for $700 a piece. 777. That's $2,100. Okay, you understand? So you can just sue individually. TransUnion 700, 1,000. Experian 1,000. Equifax 1,000. Whichever route you want to go. But after you finish suing them, and you send them the documents, they have a certain amount of time to respond to you. And it gives them 21 days. Most states are 21 days to respond as soon as they get their notice of summons of that they have a court date, or they have to respond to your lawsuit in small claims court. Here's the beautiful thing. Each one of these companies right here are a legit business. Equifax, Experian, TransUnion. They cannot come into that courtroom with a representative like an attorney. Attorneys can't come to small claims court. They're there for the people. That's your silver bullet. Because all companies, especially big ones like this, they love using attorneys, because attorneys know how to take care of business to keep them from paying anything, or getting out of wiggling out of lawsuits. So you're going to sue them in small claims court. Now, you probably saying to yourself, I owe them, like I said before, I owe them $50,000, I owe them $60,000, I owe them $100,000. You're suing them for the violations, okay? They violated responding to your affidavit. They violated the FOIA Act request. They violated your actual Fair Debt Collection Practice, truth of lending. They violated all those. So whatever number that is worth to you, you stick under the small claims value. And we're using it as an example right now, $2,500. You stay under that. Why? Because once you win the violations, the debt is gone. So you're not really trying to get them to pay you back. If you want to go all the way and win them for violations, then you can turn around after you win a small claims court and get your default judgment. You can take them to Superior Court or Federal District Court. And you start suing them for other defamation of character, or impeding on my rights to purchase another house or car in commerce. I can't even do this because you messed up my credit for all these years. You can do that. But this is the first step of getting this is the last step, really, of getting this deleted off your credit report. Most of these companies will contact you and tell you they'll remove it. They'll send you a letter saying it's removed. Most of them. When they don't, you're going to win with a default judgment, and you send your default judgment when they don't show up to court. You send that to them telling them to remove it. They'll remove it. That's what I'm trying to tell you. They're not going to come to small claims court. They have to send a representative. And they don't have time to send a representative to small claims court. They won't. And by you having exhibit A, B, and C, all of your information showing you've already won. They never responded to you correctly the way they're supposed to under the Fair Debt Collection Practice Act. They didn't respond to you correctly under the FTC. They didn't respond to you correctly under the Information Request Act. So they've been messing up, definitely screwing up. They didn't even send you legit documents. And legit documents that have to be sent to you are certified. They have to certify copies in front of a notary and send you the documents. They just can't send you colored copies of something. They want copies from you. They're authentic. You have to hold them to the same rights and fairness. So this concludes the FTC, Federal Trade Commission process. This right here will get you out of any debt that is 7 years old or older. And we're going to go into, 7 years old or older. And we're going to go into more details about the FTC, how it actually will help you with any debt with the same process right here. So I just wanted to give you the details of actually taking ownership of your life, so you can actually start a new life. You can start purchasing things that you want. You can clean up your credit, and you can actually start utilizing your taking control of your credit the way you want to, and start living your life in a way that is not putting yourself in a debtor situation. So once you clean up your credit, there's so many things you can do, you know. So stop paying these companies money to clean your credit up when they just collecting for years for off you paying, and they negotiate for you when you can actually get this done yourself in less than 90 days. You can get this done really less than 60 days. You see it. But it's as fast as you want to do it. You can get this whole thing dissolved, deleted off your credit report. Then you can watch the other videos that we will be posting, if they're not posted yet, about corporation, how to live your life through a corporation, or live your life on the private side, because that's instead of the public side. All this is done on the public side, and they take advantage of you all the time. And you got all these companies reporting to Equifax and Experian and TransUnion taking advantage of you because they can, because they know you don't know the laws that have been passed that could protect consumers. So this is Kareem Ali. I just wanted to make sure you had all the details that you need. This concludes the class. And if you have any questions, please contact Lessons 101 Store for information, and we'll assist you. You have yourself a good evening, good day, good weekend, whatever it is. Bye-bye.